The Employees' Compensation Act 1923, as amended through Amendment Act 2017. 29. Effect of failure to register agreement. Where a memorandum of any agreement the registration of which is required by Section 28 is not sent to the Commissioner as required by that section, the employer shall be liable to pay the full amount of compensation which he is liable to pay under the provisions of this Act, and notwithstanding anything contained in the proviso to subsection 1 of Section 4, shall not, unless the Commissioner otherwise directs, be entitled to deduct more than half of any amount paid to the employee by way of compensation whether under the agreement or otherwise. 30. Appeals. 1. An appeal shall lie to the High Court from the following orders of a Commissioner, namely: A. An order awarding as compensation a lump sum whether by way of redemption of a half-monthly payment or otherwise, or disallowing a claim in full or in part for a lump sum. A. An order awarding interest or penalty under Section 4A. B. An order refusing to allow redemption of a half-monthly payment. C. An order providing for the distribution of compensation among the dependents of a deceased employee, or disallowing any claim of a person alleging himself to be such dependent. D. An order allowing or disallowing any claim for the amount of an indemnity under the provisions of subsection 2 of Section 12. Or E. An order refusing to register a memorandum of agreement or registering the same or providing for the registration of the same subject to conditions. Provided that no appeal shall lie against any order unless a substantial question of law is involved in the appeal, and in the case of an order other than an order such as is referred to in Clause B, unless the amount in dispute in the appeal is not less than 10,000 rupees or such higher amount as the central government may, by notification in the Official Gazette, specify. Provided further that no appeal shall lie in any case in which the parties have agreed to abide by the decision of the Commissioner, or in which the order of the Commissioner gives effect to an agreement come to by the parties. Provided further that no appeal by an employer under Clause A shall lie unless the memorandum of appeal is accompanied by a certificate by the Commissioner to the effect that the appellant has deposited with him the amount payable under the order appealed against. 2. The period of limitation for an appeal under this section shall be 60 days. 3. The provisions of Section 5 of the Limitation Act 1963, 36 of 1963 shall be applicable to appeals under this section. 30A, omitted by Act 11 of 2017. 31. Recovery. The Commissioner may recover as an arrear of land revenue any amount payable by any person under this Act, whether under an agreement for the payment of compensation or otherwise, and the Commissioner shall be deemed to be a public officer within the meaning of Section 5 of the Revenue Recovery Act 1890, 1 of 1890. 32. Power of the state government to make rules. 1. The state government may make rules to carry out the purposes of this Act. 2. In particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely: A. For prescribing the intervals at which and the conditions subject to which an application for review may be made under Section 6 when not accompanied by a medical certificate. B. For prescribing the intervals at which and the conditions subject to which an employee may be required to submit himself for medical examination under subsection 1 of Section 11. C. For prescribing the procedure to be followed by commissioners in the disposal of cases under this Act and by the parties in such cases. D. For regulating the transfer of matters and cases from one commissioner to another and the transfer of money in such cases. E. For prescribing the manner in which money in the hands of a commissioner may be invested for the benefit of dependents of a deceased employee and for the transfer of money so invested from one commissioner to another. F. For the representation in proceedings before commissioners of parties who are minors or are unable to make an appearance. G. For prescribing the form and manner in which memoranda of agreements shall be presented and registered. H. For the withholding by commissioners, whether in whole or in part, of half-monthly payments pending decision on applications for review of the same. I. For regulating the scales of costs which may be allowed in proceedings under this Act. J. For prescribing and determining the amount of the fees payable in respect of any proceedings before a commissioner under this Act. K. For the maintenance by commissioners of registers and records of proceedings before them. L. For prescribing the classes of employers who shall maintain notice books under subsection 3 of section 10 and the form of such notice books. M. For prescribing the form of statement to be submitted by employers under section 10A. N. For prescribing the cases in which the report referred to in section 10B may be sent to an authority other than the Commissioner. O. For prescribing abstracts of this act and requiring the employers to display notices containing such abstracts. P. For prescribing the manner in which diseases specified as occupational diseases may be diagnosed. Q. For prescribing the manner in which diseases may be certified for any of the purposes of this act. R. For prescribing the manner in which and the standards by which incapacity may be assessed. 3. Every rule made under this section shall be laid, as soon as may be after it is made, before the state legislature.